Hi, this is Jeremy Worley with the Injury and Disability Law Center, and I want to talk about premises liability because this is something that gets thrown out there a lot, and a lot of times people don't really know what it means. So let's start by talking about what is premises liability. So, premises liability just simply means that a property owner has not kept their condition in a reasonably safe condition, which then leads to injuries by someone on that property. And so you often hear about this. This is what slip and fall cases are, or trip and fall cases. That all falls under the umbrella of premises liability, but it can also include other things. It might be dog bite cases. So if you go on someone's property and you're attacked by a dog, oftentimes it can also be things like staircases. It may be a wet floor at a store that you go in. It really can be any number of different things, even things like negligent security or insufficient security at a location. So it's a pretty broad term, but really generally it's talking about unsafe condition of property that leads to damages that's by someone that is on that property. And so the most common by far is what we would call the slip and fall cases. That is your example of for instance, you're in a store, you slip on something and you are injured. Now, this has some unique properties with it, okay? Because what makes it unique is that the property owner, there is a legal standard that says they either knew or should have known. So anytime you have a condition on a property, one of the questions that's going to be examined is, did they know about it, for one, or should they have known about it through reasonable inspection and reasonable actions? Well, that can be very difficult to prove. Let me give you an example. If you walk into a store and you slip on a clear liquid in a store, one of the questions is going to be, what is it? How did it get there? But also, how long has it been there? Okay, there's a very different case if it's been there 5 seconds, someone right before you just happened to drop it and you slip on it 5 seconds later. That's very different than a claim in which maybe the liquid had been on the floor for 24 hours and nobody cleaned it up. And so that becomes a very challenging type of case oftentimes to prove the negligence on the part, because we oftentimes don't know how that liquid or that condition got there. So proving up premises liability cases can be very difficult. And oftentimes I find people are a bit hesitant to bring a claim because there is an embarrassing factor to it. I slipped and I fell. But one common mistake that people will make that I want to clarify is, just because you fall in a store does not mean that you immediately have a claim. Okay, there has to be some form of negligence on the part of the property owner. And so if you call and talk to me, one of the first questions I'm going to be asking and talking about is what caused you to fall? It can't simply be, I happened to fall in the store. The other part of a premises liability claim that often comes up is comparative fault. And that just means, did you have any fault in causing your injuries or causing yourself to fall? Okay, if you weren't paying attention, or you were wearing specific shoes that might have been dangerous, or you were carrying a bunch of things. So we always have to look carefully about whether the defense is going to argue that you were partially at fault. And in New Mexico, that can be split. It doesn't mean that the store owner would be 100% and you 0%. It can be divided up, so you might have partial fault. So these are the factors that we look at. In every situation, we have to consider, what did the property owner know and what should they have known in order to keep you safe on their property. So if you've been a victim of a slip and fall, trip and fall, or maybe you were injured on somebody else's property, give me a call and let's talk about it, because it's hard to make a video that captures everything, but I did want to hit on some of the high points. They can be very challenging cases, and so it's important that we talk through the unique factors of your case. So give us a call, 575-300. Visit us at idlawcenter.com. We'd be happy to take a look at your case and see if we can help you.